Hello, I'm Morris Fisher, and welcome to our YouTube channel. And we invite you to become a subscriber to our channel. It's free, and you get access to all of our podcasts. Today, I want to take a look at the actual text of the executive order everyone's talking about. This is the one signed just a few days ago by the president, and it's the Return to Person Work Executive Order. And it's the one that requires all the federal employees to basically give up their telework and go back to full-time in-person work. Before we address the actual language of the executive order, I think it's important to address one issue in particular, and a lot of clients have had this question, and that is, can these executive orders be overturned? Do they really have the full force of law? Well, what is an executive order in the first place? It is something that the President of the United States uses to make the executive branch of government, which consists of all these different agencies, better, more efficient, more useful, the way that the president sees fit. So these executive orders really are supposed to be limited for that purpose. So if there's an act of Congress, such as Title VII, which stops race, gender, religious discrimination, so the president cannot sign an executive order that nullifies Title VII. That's something that has to go through the Congress. And that's true even if there's a proposed law that doesn't make it through Congress. And we saw this with some of the immigration laws that Congress tried to pass, and they couldn't. There wasn't enough votes for them. The president really cannot then go ahead and say, well, what Congress didn't do or couldn't do, I'm going to do through executive order. That really is unconstitutional. The other exemption that's pretty big here is that if the executive order is already in conflict with some other executive order that hasn't been revoked. So assuming that this executive order passes all of those tests, the language of the order, which says that heads of all departments, I'm not going to read it word for word, but it's basically that heads of the departments and agencies in the executive branch of government have to, as soon as practicable, basically get all of the federal employees not to telework anymore and return to work in person at their respective duty stations on a full-time basis. The order does say, however, that provided that the department and agency heads shall make exemptions as they deem necessary, and that this memorandum shall be implemented consistent with applicable law. So the first language I want to talk about is this business about the department and agency heads shall make exemptions. Well, what are those exemptions based on? Is there illegal favoritism? Is someone allowed to telework because they fall under a protected basis other than disability, while others who aren't in that protected basis don't have that right? Or can someone telework because of their political beliefs or marital status as opposed to others who had different political beliefs or a different marital status? And the answer is no, none of this favoritism is allowed. There are laws against that. So this is going to lead to a lot of conflict here at a lot of these federal agencies, because what are these exemptions going to be based on? And there's going to have to be many of them, because by definition, everyone under this law, under this executive order, can no longer telework unless there's an exemption. Or, as the executive order states, the memorandum has to be implemented consistent with applicable law, which, by the way, even if the executive order didn't say that, it would still have to be consistent with applicable law. That is a reference, I believe, to disabilities, that employees who have disabilities, who can't make it into the office, because of their disability, and they have to complete a reasonable accommodation request, unless there's an undue hardship to the agency, that employee has the right to telework. So, what should employees do at this point? My office has seen a number of cases where there are disabled employees who have telework agreements, but those telework agreements are not based on disability or need for reasonable accommodation. Now, there could be a number of reasons for that. You could have employees who just had a very lenient boss and didn't want to make that employee go through the headache and the 14 steps of getting a reasonable accommodation. Why do that if you don't have to? Well, now you're going to want to do that. You're going to want to convert your telework agreement. You should really be checking your telework agreement. What does it say? And is it based on disability or reasonable accommodation? If it isn't, you're just one of these other employees officially that's just part of the pack. And to a judge or to a jury, it will certainly look like you didn't have a real disability if the defense lawyer is doing a good job at trial. So you want to convert that right away. You want to make sure that your supervisor and manager knows, and certainly the head of the department knows, you're an exception, not because were picked to be an exception, but because you have a disability. And you go through the steps and you apply with the Office of Civil Rights for your disability. And this right now, in the early days of this new administration, this is the time to do this. Again, we invite you to subscribe to our channel. It's free and you get access to all of our podcasts and all the valuable information. And if you are in need of an employment lawyer for any reason, including completing reasonable accommodation requests, give us a call. It is what we do.